Hello and welcome to America Can We Talk? I'm Debbie Georgatos. Thanks so much for tuning in today. Today we're going to talk about the Trump tax battle going to the courts, the state of religious freedom in 2019. Lathan Watts of the First Liberty joins me. Insulting Congress should be a crime, and Austin OK's Sidewalk sleepers with some exceptions. And of course, I'm going to tell you why these stories matter to you. Stay tuned.
Debbie Georgatos, host of America Can We Talk, is an author, attorney, and political analyst whose mission is to inspire the American political conversation about preserving liberty in the best country on earth.
And welcome again to America Can We Talk and to today's First Five. There's a battle brewing in Washington over whether the Democrats in the Congress can actually get their hands on President Trump's tax returns. I just want to plant the seed. We're going to follow this story, of course, but I want to plant the seed that the federal law that applies to the question of whether or not Congress can get a hold of President Trump's tax returns was passed by Congress in response to President Nixon's efforts to use people's tax returns against his political enemies. Nixon was trying to get tax returns of people he didn't like, and he was doing that in such an egregious manner that Congress passed a law, Section 6103 of the Internal Revenue Code, guaranteeing the confidentiality of all tax returns, yours, mine, even President Trump's. So the Democrats are trying to say essentially they have some reason. The point, by the way, the point of that law was you can't seek tax returns just for partisan politics. You have to have a reason. There is a federal law that permits the heads of certain congressional committees to get tax returns of taxpayers and many other people, but you can't be doing it for political reasons. So President Trump has retained apparently just a phenomenal tax attorney who's already said, and by the way, has already told Congress that the Trump administration, are not authorizing the IRS to release the tax returns. They've told them that they are going to stand on President Trump's right to have privacy in his tax returns. What the people from Congress are asking for is Chairman Richard Neal of the House Ways and Means Committee. He's asked the Internal Revenue Commissioner, Charles Rettig, for copies of tax returns by President Trump and 8 of his companies for the last 6 years. This is clearly as they say in the law, fishing expedition. This is, can we find something to get this guy? And you know, if you're one of the people thinking, well, if Trump hasn't done anything wrong, why doesn't he just give them the tax returns just to make them happy? And the answer is this: nothing he ever does will make them happy, number one. And number two is, any lawyer worth their salt, frankly, any first-year law student who'd taken a tax course, can find something in some tax return that they could argue was not applied correctly, the exemption was not available, the exception doesn't apply to you, the numbers were somehow off. All this will do, if President Trump were to concede and give his tax returns to Congress, is open a whole new flood of attacks about what his tax returns did, what they said, what they shouldn't have contained. It will never end. President Trump is right to stand strong against this congressional effort, this fishing expedition, to try to find something they can attack him on. Much more to come, I'm sure, but I want to just weigh in at the start to say, you gotta fight these people every step of the way. The mission of the Democrats is not any legitimate, in this case, not any legitimate concern about tax fraud. It is hoping to find something, further evidence in their worldview to ultimately bring them around to be able to bring impeachment against him. That's all they're looking for, is some grounds for impeachment. No reasonable lawyer would advise President Trump, well, go ahead and give it to them, we'll work with them. It doesn't work that way in Washington today. And that, my friends, is today's First Five. We return now. I mentioned in the introduction today, we have Lathan Watts joining us. He is the Director of Legal Communications for First Liberty Institute. We've had different people from First Liberty on the show many times, and I will let him tell you the details about First Liberty. But basically, they're a law firm here in Dallas, or I don't know if you're a law firm, you call yourselves a firm, law firm?
Law firm and think tank, yes.
Yeah, and think tank that defends religious liberty. They have the most amazing, interesting cases. And I thought on this day before July 4th, and this day we're going to celebrate tomorrow, the Declaration of Independence and a country founded on religious liberty. It'd be a great time to catch up to see how we're really doing on religious liberty in America today. So first, welcome.
Thank you very much for having me.
So glad you're here. There are been so many religious liberty cases, and I want to just kind of run through them, not just to have you tell our listeners what happened, but what's kind of the thinking behind them, and what is the reason that these cases are even coming to the forefront. The big one I wanted to start with involved the Bladensburg Cross, and I did, for our listeners, I did talk to you about this case. It was the enormous cross that ended up after some road reconstruction being in the middle of a public road, but it was constructed by or erected by women back after World War I, honoring their sons who were lost in the World War I. And and I'm not sure who was the plaintiff. This I'm sure you know who was the plaintiff.
The American Humanist Association.
Oh, the folks friendly to religion. So, Supreme Court came back on the Bladensburg case. Just tell me about that decision, what the court had to weigh and how they came down.
Certainly. So it was a big win, 7-2, and it is, pardon the pun, a monumental decision.
That's a good pun.
Because it really is sort of a whole new day in America when it comes to the court's Establishment Clause jurisprudence after this decision. This, as you said, the Bladensburg World War I Memorial had stood for nearly 100 years until the American Humanist Association sent a couple of lawyers to drive by and get offended by it and file a lawsuit to tear it down because it is in the shape of a cross that now sits on land that's maintained by the state of Maryland. So we actually won that case at the district court level, and they appealed to the Fourth Circuit. At oral argument, one of the justices of the Fourth Circuit suggested we just cut the arms off the cross, and that would somehow
that was so practical.
Make it constitutional. So, not surprisingly, we appealed that decision to the Supreme Court. They took the case. We had oral argument back in February, and we just got the decision about 2 weeks ago. So, in a 7-2 decision, really a brilliant opinion written by Justice Alito to be able to get Justice Breyer and Kagan to come along with him, because I can tell you, after oral argument, sort of the conventional wisdom around our office was if the decision comes out and it's 7-2 or 6-3, it's likely going to be a narrow one that protects the memorial but doesn't really address the bigger problem in this area of jurisprudence, which is Lemon versus Kurtzman. And we thought, well, if it comes out and it's 5-4, then we probably got everything we wanted because they couldn't get the liberals to come along with them. So when we first heard it was 7-2, I was kind of like, oh, well, I mean, it's a win. And then I started reading the opinion. And it is just about everything that we asked for, including the fact that the majority opinion states that Lemon versus Kurtzman is no longer going to be applied in cases involving religious monuments, imagery, activities in the public square. And it's hard to overstate what a big win that is for religious liberty.
I want to jump in before
Sure.
because people may not know this. To start with, the First Amendment, under which all the religious liberty cases are litigated, the First Amendment, the relevant portion says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So the legal question in the court was, does having a cross stand on public land constitute an establishment of religion? And so what Lathan's referring to, and it's actually, I love that you're here to explain it. The Supreme Court had previously established a test, looking at a set of facts in a case. How do we decide if this set of facts constitutes a violation of the Establishment Clause? And in a case in which one of the parties happened to be named Lemon, so it's come to be called the Lemon test. But the Lemon test originally had a three-pronged thing about how you decide the Establishment Clause problem has occurred.
Right. So it was a very complicated, very fact-specific test that the court devised in that case. And the result of it really, it caused more confusion than it ever clarified. And it created this scenario in which almost every time the test was applied, the subject matter in question ended up being ruled unconstitutional. If you failed any one of the three prongs of the test, then it was unconstitutional. And so it kind of developed into this test that nothing could pass. And courts were confused as how to apply it. Sometimes they did, sometimes they didn't. So at oral argument, we argued, not only does the Bladensburg Memorial not violate the Establishment Clause, but it is time for Lemon to be put to death. I mean, once and for all. Justice Scalia had once referred to it as like a ghoul in a horror movie that just keeps coming back. And so that was the argument that we made, and the majority opinion says it's no longer going to be applied in cases involving monuments, memorials, activities in the public square are now presumably constitutional if they fit within the longstanding history and tradition of this country, which this memorial did and thousands of others do.
I want to jump in and just on this lemon test thing, because I remember memorizing this in law school. But the lemon test, how they used to decide if some monument or other thing violated the Establishment Clause is there a secular legislative purpose? Is there a secular reason for it? Is the primary or principal effect of in somehow not inhibiting religion, not advancing or inhibiting religion, so primary effect test. And then the excessive government entanglement test. Does something about this does it result in excessive government entanglement? And I'm glad you made that point. The way the decisions, the way the lemon test was set, too many cases fell in the court's view as became violation of the Establishment Clause. And so it really kind of eviscerated the real meaning of the Establishment Clause, which, what was the original purpose of the Establishment Clause?
Certainly. I mean, the intent was there will be no national church of the United States of America. Point blank. That's it. I mean, they just fought a war with the greatest empire in the history of the world that had the Church of England that you were taxed to support. And they did not want that for this country. And so really anything that's not coercing someone to worship in some way or compelling them to support some state-sponsored or approved church is not a violation of the Establishment Clause. And that third prong of the lemon test that you talked about is excessive entanglement. Well, who decides what's excessive entanglement? And that's why it ended up where government is supposed to be neutral towards religion, this test ended up making it hostile towards religion.
Yeah.
And to the point where just about every time it was applied, like I said, everything was ruled unconstitutional. So now we have a presumption of constitutionality, which completely shifts the focus and the analysis back to the original intent of the Constitution. And if in returning to that, our client in the case was the American Legion, who originally donated the property. The American Legion's already identified 3,000 memorials across the country that are safe now.
Wow.
Because of this decision.
It is a consequential decision. Yeah, that's great. Okay, there's a bunch of cases I was hoping to hit. The next one is a sweet cakes decision. Is there any final thing you want to say about Bladensburg? Sorry, did I wrap up here?
Yeah, one other thing about the decision. If you read the concurrence by Justice Gorsuch joined by Thomas, he also makes the point that with Lemon safely put on the shelf, you have also done away with the offended observer status.
Oh, is that ever excellent?
Yeah, because what that means, the reasonable observer standard, which was part of that excessive entanglement prong of the test, that if a reasonable observer thought that there was excessive entanglement, it was unconstitutional. But what that morphed into was the offended observer. As soon as someone was offended by something, they filed a lawsuit. And Gorsuch and Thomas say, if we're doing away with this, then these types of lawsuits should be dismissed for lack of standing, which means folks like the American Humanist Association, Freedom from Religion, who run around the country getting offended and filing lawsuits, are going to have a very tough time surviving motions to dismiss on these types of cases from now on.
Yeah, that was an excellent ruling. And that offended observer thing is just, you're setting anyone up, as you say, who has an hostile attitude toward religion to be offended and file a lawsuit. I love that it took away. Okay, I love that. Next one was a sweet cakes decision, and we talk about that in the show many times, but
right.
The people who own a bakery, is it in Portland? Where is it again?
In Oregon, yeah.
In Oregon?
Yeah, near Portland, I think, is the closest big city.
Yeah, and these are bakery owners who love to make custom wedding cakes, among other things. Anyone's welcome in their bakery all the time, but when they're asked to make a wedding cake, they customize it to the couple. They're very particular, get to know the couple, make it tailored to them. They are devout Christians, and they did not want to be putting their creative energies into building a cake, making a cake for a same-sex wedding, because that same-sex marriage was inconsistent with their religious views, with their Christian views. They had a long battle, which isn't worth reviewing, except to say they had a long battle, which they ultimately lost their business, and they were fined a large amount of money, told at one point by the Oregon, whatever the agency is called, they couldn't even talk in public about their views about marriage. And so they finally got in front of the Supreme Court. This is sweet cakes. What happened there?
So yes, we got that decision the same week we got the Bladensburg decision, so it was busy around our office, but it was a good busy. The Supreme Court did what's called grant, vacate, remand. So they heard basically the appeal on paper, vacated the Oregon Court of Appeals decision, sent it back to the Oregon Court of Appeals saying you need to do this again in light of the Masterpiece Cake Shop ruling from the previous term, which says clearly says you cannot be hostile towards the religious beliefs of the citizens. And so now Aaron and Melissa Klein have a shot at a fair hearing in front of the Oregon Court of Appeals, which if they get it right, that will be over for Aaron and Melissa, and we would love that. If not, then we will go back to the Supreme Court and give them a chance to not only protect Aaron and Melissa, but part of our brief in that case was also to have them review Employment Division versus Smith, which is the other really, really bad precedent for religious liberty. It is to the Free Exercise Clause what Lemon was to the Establishment Clause. Mm-hmm. So hopefully Oregon Court of Appeals gets it right. If not, it may actually create an even bigger opportunity to remedy a really bad case on the Free Exercise Clause.
So again, I read to you the First Amendment, the Establishment Clause, and the Free Exercise Clause, and the argument that people like the owners of Sweetcakes would be saying is, I'm essentially being forced to exercise a religion or take an action that's inconsistent with my religion, and that violates my free exercise. So if I recall correctly, the Masterpiece cake out of Denver area,
yes, Denver.
There was some disappointment because the Supreme Court didn't flat out say it's a violation of the Free Exercise Clause to force a citizen to do something inconsistent with their religious faith. Instead, they essentially said you can't pressure. I'm sorry, with the language of Masterpiece.
It's basically you can't be biased. They said the Civil Rights Commission in Colorado was openly hostile towards the man's religious beliefs, and so there was no way he got a fair hearing there. And they said the same thing about the Oregon Bureau of Labor and Industries, which has a Soviet ring to it to begin with.
Yes, it does.
But they said the same thing about them. That you were clearly hostile to these folks. You need to do this again and give them a fair hearing.
So, I remember talking at the time, actually on a different radio show I do, about the Masterpiece case. So as long as the state agency was more polite and more deferential and didn't say rude things about your religious beliefs, you maybe could survive that standard from the Supreme Court because they didn't exhibit hostility, right?
Correct. And the reason that Masterpiece and our case, Sweetcakes, were brought as free speech claims, saying that this is actually government compelling this person to speak a message with which they sincerely disagree, is because the Free Exercise Clause and case law under free exercise has been roughly dormant after Employment Division versus Smith.
Which essentially holds?
Basically lowered the bar of scrutiny to say that if a law is neutral on its face towards religion, but it just happens to prohibit you from freely exercising your religion, well, it's okay. And so that's why these types of cases, you see them being brought as free speech cases, not as free exercise claims, because it is religious speech, and so we can bring it under First Amendment free speech grounds and have a better chance of winning, which is why if we get a chance to bring that back to the Supreme Court, we ask them to review Employment v. Smith.
It's a very good point. I love all this. I think the law is so interesting, and these cases are so interesting. And, in this, back to this being the day before July 4th, and the entire reason America was founded, or that the people left England and other places and came here, was to seek religious freedom. It's the primary, it's the first, why you call it first liberty. It's the first guarantee in the Bill of Rights that we have the right to freedom of religion. So these are really important cases, and that's going to segue well into the next thing I want to talk about, which is the Chick-fil-A situation in Texas. Right. It's very interesting because we have the Supreme Court say that you have to, and that essentially legitimized same-sex marriage. And so you have people viewing that decision, saying, Obergefell saying you have a right to same-sex marriage, that your right to same-sex marriage should be equal with a religious freedom right. And so some people, and this is why it segues well into Chick-fil-A. Chick-fil-A is a Christian family-owned business, and they're open to anyone all the time. They serve anyone, but their owners have been outspoken about their traditional Christian faith and support of traditional marriage. So the city of San Antonio, in the great state of Texas, barred Chick-fil-A from being at the San Antonio airport, and that caused it because they were claiming that Chick-fil-A being opposed to, the owners being opposed to same-sex marriage, were essentially discriminating against same-sex couples, and Chick-fil-A owners saying, hey, we're just Christians and we're allowed to think what we think. And so it became a battle of butting heads of a Obergefell same-sex marriage right from the Supreme Court, but what about and so Chick-fil-A ended up where we are right now, the state of Texas passed a law essentially trying to force, I don't know if actually the law passed or not, but where we are right now is that we have federal and state investigation into San Antonio about their refusal to let Chick-fil-A be at the airport because of their Christian views. So have you guys gotten involved in that at all?
We have. So when that first happened, we sent a letter to the Department of Transportation because the expansion and the upgrades at the San Antonio airport were due in part to a federal grant that they got from the Department of Transportation. And everybody who receives federal grant funds is required to comply with anti-discrimination sections of as a condition of getting the grant. And clearly, the city of San Antonio was discriminating against this company based on their religious beliefs. So we sent a letter to the Department of Transportation, just asked them to look into whether or not they were in compliance, and if not, they should have to give the grant money back. And not long after that, the FAA, which is under DOT, announced they were investigating both San Antonio and the city of Buffalo, New York, did the same thing. The city of San Antonio, when they approved the concessions contract for the new section of the airport, approved it on the express condition that Chick-fil-A would not be allowed to be a vendor there.
Wow.
It
They
was
actually
attached
had divulged
to,
that.
Yeah. I mean, it was a part of the vote. So, I mean, it was blatantly obvious. So we asked for the investigation, and now it's underway. We also, First Liberty also filed open records requests for emails, statements, basically anything discussing this decision to see if they had communicated in a way that indicated their bias against the religious beliefs of these folks. Of course, they were not too eager to give us any of that and did not want to comply with the open records request, so they appealed to the Texas Attorney General, who is also suing them for the same thing.
Okay.
So now, we're hoping that the Texas Attorney General's response is just make 2 copies of everything and send one to my office and one to First Liberty's office. So that is now ongoing, and we'll wait and see what we get from the city of San Antonio.
So what is, you are an attorney, you're focusing on religious liberty, you're with First Liberty. Mm-hmm. What is the legal answer to the question, why, if the Supreme Court has acknowledged that same-sex marriage is permissible and must, not just permissible, but must be honored, why can there still be respect for the First Amendment free exercise right of Chick-fil-A and its owners and other people to not support or indulge or agree with same-sex marriage? I mean, how's that square out under the Constitution?
Well, I think the simplest way is that we don't punish thought in this country. And what our clients in Oregon were seeking to do, as we've said many times, they would serve all people, but they would not speak all messages. And the state of Oregon bankrupted them with a penalty of up to was $135,000, which basically bankrupted their business. And as you said, initially told them not to speak their beliefs on marriage.
Yep.
And that is viewpoint discrimination. That is the government saying there's only one acceptable view when it comes to the marriage issue. People have the right to disagree. Everybody, no matter what you believe about marriage, we can all agree that everybody has the right to live according to their beliefs. And so in the post-Obergefell era, I think you have 2 groups of people trying to figure out how to peacefully coexist. And on 2 ends of the spectrum is intolerance that really should not be in our country. One is we don't serve your kind here. Okay, that's Democrat, Jim Crow nonsense has been illegal in this country for 50 years that nobody wants to go back to. Not our clients, none of the people involved in these kind of cases. On the other end, and just as wrong, is the government will decide that there is one viewpoint that is acceptable, and we will punish you for not speaking it. And that's what Aaron and Melissa Klein experienced. They felt like participating in this ceremony was speaking this message of that the government wanted them to speak. And if
to condone same-sex marriage.
Exactly. And if you have a right to something, you inherently have the right not to do it also. So if you have the right to speak, you have the right not to speak. You have the right to freedom of assembly. You have the right not to participate in the assembly. And so that's what we're seeing is these 2 groups of people trying to figure out how to peacefully coexist. And the reasonable middle ground is what our clients were trying to do, which is to say, you know what, if you won't ask us to be a part of your wedding, we're not going to ask you who you're sleeping with if you come in to buy muffins in the morning, right?
We don't really care. Yeah.
Exactly. I mean, that should be a way that we can all get along.
One analogy I made, because when the sweet cakes case came out and Masterpiece Bakery case was ongoing, it helped me get a clearer view of it. Because, so you can imagine the argument, if you own a bakery and you say, and as Lathan was just saying a moment ago, we long ago have said in this country, you don't permit businesses to say, we don't serve women, we don't serve people of a particular race or ethnicity. You can't do that. And so that argument seems like people could say, well, then therefore, why can't Sweet Cakes or Masterpiece Bakery, the Denver one, why can't they bake a cake that somebody wants? Aren't they essentially doing the same thing? But the reason that free speech and really freedom of religion are both part of that is because they are being asked to use their artistic skill, their artistic ability to design a cake to honor this particular couple. In the case of same-sex couples, they would be forced by the state to use their expression, their free speech, to honor something they don't want to answer. And as the short-term analogy I have said sometimes, it'd be like if I were told I had to make a speech saying why Hillary Clinton would have been the best president ever in America. This would be, I don't believe that, I should never be forced to make that speech. In the same way with the Klein, the bakery and Sweet Cakes, and you shouldn't be forced by the government to say something you don't agree with, especially when the reason you don't agree with it is tied to your religious beliefs, your sincerely held religious beliefs. So, and I love your point. I want to finish one more thing on this, which is this coexistence issue. You can have bakeries like Sweet Cakes and Masterpiece and other bakeries who happily will make a wedding cake for people who are pushing, throuple marriage or,
Sure.
or any marriage that you want, that you can have, there'll be bakeries available. But the insistence or the intolerance is really on the side of those saying, no, you must be forced to make a cake that honors my view of marriage, right. And you must therefore you're going to be forced on you, right, to make a cake that violates your view of marriage. And I think there is this peaceful coexistence idea that you can have same-sex marriage legal under Obergefell, and you can have individuals with the right to not speak when they don't want to speak, to not be forced to give a message they don't believe in. That peaceful coexistence, I don't know what the constitutional premise would be behind it, but that's the right idea of honoring both sides' rights, I think.
Yes, exactly. I mean, it's basically that your rights don't trump mine. Okay, we both have them, and we both have the right to live according to what we believe, and that's what the free exercise clause is really about. It is, there's a really dangerous interpretation of the free exercise clause that you hear from some people, that it's about your right to believe whatever you want to believe, or they call it the right to worship. Well, that confines religious belief, between the ears of the faithful or to the four walls of your church on Sunday. And the founders intended us to be able to live according to our beliefs every day of the week. And if you want to run a business according to your beliefs, because this is not the only type of cake that Aaron and Melissa would politely refer someone to another bakery for. I mean, if somebody came in and wanted a cake celebrating their divorce, they would refer them to somebody else. They're not going to speak that message. There are certain things around Halloween that they didn't want to be a part of, and they would refer people to another bakery, just like they did here. So if Aaron and Melissa ran the only bakery in Oregon, then you might have a case of, okay, yeah, they should be forced to do this. But all they did was refer them to another bakery who was happy to make the cake for them. It would be, analogous to going to a kosher deli or a kosher bakery and asking for a
pork sandwich.
Right, or a cake to celebrate Hitler's birthday. If some skinhead went into a Jewish baker's shop and asked him to make that, he's probably not going to make that cake, nor should he have to.
Right. I love that. There is something about the mutual, peaceful coexistence, mutual respect that needs to be inserted in the discussion. Last case on religious freedom, I'll quickly run by you, and I thought was so interesting, was that the Pennsylvania National Guard, which apparently is the overseer of some public property that is historic in nature. Right. The point of it is they give permission for various groups to come in and tour and walk through and see it. So Pennsylvania National Guard decided that a new organization, or new to me anyway, Trail Life USA, I think it's akin to Boy Scouts with a little bit more religious flavor to it.
Right, it's like a Christian scouting program.
Christian scouting, okay. So Pennsylvania National Guard told Trail Life they could not come and get this tour because that would constitute an establishment or religion, I guess, was their argument. So tell me what happened there.
Right. So the Trail Life USA wanted to bring their troop to tour this facility, and they went through all the proper requests and paperwork, and were initially told that they would be happy to give them the tour. And then upon finding that they were a religious organization, the tour was kind of sort of taken back and said, "No, actually, we're wrong. We can't do that because that would somehow appear that we are favoring religion over or non-religion or one religion over another." And it gets back to what we've talked about before about a misunderstanding of what the First Amendment is all about. We worked with a Pennsylvania policy group up there and sent a letter up to the Guard and explained this is actually what the situation is what the law is. And thankfully, they remedied the situation very quickly, and the troops going to get their tour, and we're happy for them. Well,
I'm going to add, I mean, I'm glad I didn't get the litigation, just took a letter. And what I want to make the point on that is that the way the Pennsylvania National Guard handled that, it is a product of the cultural message being sent so frequently by the American humanists, by the separation from what's it called? Freedom from religion. The people who are just stridently arguing that religion can have no place in public life, no place at all. So the easier answer, if you're the Pennsylvania National Guard and you're worried maybe it's unconstitutional, you may be fearing either a lawsuit or at least public attention you don't like. It's easier to decline to have any connection with religion, and it is a result, though, directly of this confrontational, aggressive attitude in litigation by these groups. So you kind of can't blame them because they're probably just trying to keep themselves free of litigation, but it really needs a pushback was vital. I'm so glad you did. First
and those groups count on that. They count on that sort of response. They'll send out thousands of letters a year threatening to sue you if you do this, that, or the other when they really maybe
like these
sue,
groups being
maybe
humanists?
Like Freedom from Religion, American Humanist Association, Americans United for Separation of Church and State.
That's what I couldn't think of.
There's multiple ones. They count on that response. They'll send out thousands.
They count on bullying America.
Exactly. On sending out thousands of letters, knowing that they're really probably maybe going to sue 10 people in a year. But they hope that organization reacts just the way the National Guard started to until we were able to clarify it for them. And it gets back to the case we were originally discussing, the Bladensburg opinion. Justice Alito said, "A government that roams the land, tearing down monuments with religious symbolism and scrubbing away any reference to the divine, will strike many as aggressively hostile to religion." That's exactly what those groups are doing.
Yes,
they are roaming the land, looking for something to get offended by, and hoping they can get government to scrub it out of public view. And those days are over, thanks to this decision. That Lemon goes back to the early 70s, so I can, without exaggerating, say I live in a freer America than I have ever lived in my lifetime, because Lemon was older than I was.
Okay, you're a very young man. Okay. And on that note, will you just share with our listeners the website for First Liberty?
Certainly. It's firstliberty.org, or you can text the word liberty to 474747. You'll get a text back to get on our email list and get updated that way.
Okay, they have great emails, great informational emails, great website, lots of information, always available about liberty and freedom of religion in America. So, Lathan, thank you so much for coming in today.
Yeah, appreciate it.
Thank you. Okay. And folks, I want to turn where this is kind of the day before our July 4th, and I'm going to hit a couple other points, stories today quickly. There is a constitutional scholar. Okay, no, I promised myself it wasn't going to be a snark. There is a member of Congress who's not a constitutional scholar. Her name is Representative Frederica Wilson. She's a Democrat from Florida, and she weighed in on the subject of whether or not Americans should be free to speak their mind online if they want to criticize a member of Congress. So here we have a clip. I believe my wonderful producer Matt has Frederica Wilson. Here she is.
Those people who are online making fun of members of Congress are a disgrace. And there's no need for anyone to think that is unacceptable. We're going to shut them down and work with whoever it is to shut them down, and they should be prosecuted. You cannot intimidate members of Congress, threaten members of Congress. It is against the law, and it's a shame in this United States of America.
Okay, what I want to say about that is, it is true. One little piece of what she said is true. You can't intimidate or threaten. If someone were to put online a threat against the safety of any person, whether they're a member of Congress or it's a guy next door or someone in another state. You can't threaten people. That is true. You might be charged with something. What she is complaining about, though, is that people online happen to disagree with her, and I'm going to guess even sometimes mock her. And she doesn't like that. She's really arguing that because she is the ruling elite, she's a member of Congress, people online cannot criticize her. They're not allowed. And, you know, I'm sure she got back to Congress and somebody in Congress, some legal team, or maybe her own staffer said, hey, by the way, you know, you really can't say that. Of course, people in America can criticize you. But the attitude she is exuding in that little clip is just this ruling elite. Nobody ever better dare insult, criticize a member of Congress. And so I want to call that to your attention to say, I'm sorry, I didn't mean to be a smart aleck. She's not a congressional scholar. She's not a scholar at all. But she is really of the mindset that does deserve rebuke in this country, because we do have a testy, elitist attitude among some members of Congress. And it's the healthiest thing in this week of Independence Week, when tomorrow we're celebrating July 4th and we're loving on our First Amendment. People get to say things even that politicians don't like. And the final story for today has to do with the city of Austin. Now, I do this show from Dallas, and if you listen from around the country or other countries listen to this show, you may not know that even in the great state of Texas, which everyone thinks is really conservative, we have the city of Austin, which is their slogan, not kidding, is keep Austin weird. They love that. Austin's a very liberal city, a liberal jurisdiction within the great state of Texas. We have a few more of them, but Austin's a big one. So Austin City Council passed an ordinance that, let me back up and say, the city council in Austin had people come and present to the city council their concerns on behalf of the homeless, and basically saying, you know, we don't have enough places for the homeless to sleep at night. So you, city council, you need to pass an ordinance letting them sleep anywhere they want in the city. Just let them sleep on sidewalks. Let them sleep anywhere they want. The city council, in an ever elitist attitude, passed an ordinance saying, well, yeah, pretty much homeless people can sleep anywhere they want, except, of course, not on City Hall property and not in public parks, areas that the city, are responsible to keep clean. So we have now in the city of Austin, it's legal for people to sleep on the sidewalks. If you're listening from California, or especially if you're listening from San Francisco, you might be thinking, hey, yeah, you know, it's happening here too. It is true. It's true in San Francisco. That has become, not only can you sleep on the streets, but you can relieve yourself. You can do anything you want on the streets in San Francisco. All of this indulgence of the homeless population, and literally making it more and more difficult for tourists and citizens to walk the streets safely. One little thing I decided not to put it up on the screen because this is off of Facebook, but a woman who lives in Austin was talking about, you can see a picture of her house. She gets home, there's a homeless person sleeping on the sidewalk in front of her house. Very house next door, and these are like row houses connected, very house next door has a for sale sign in front of it. Imagine trying to sell your house and people coming to see it with someone on the sidewalk. So she called the city. Question: people are sleeping on the sidewalk in front of my residence. This is concerning to my family. Can't y'all do something about that? Answer: no. The new obstruction/camping ordinances allow camping on sideways, alleyways, and other public spaces, except parks and City Hall, which includes in front of your house, provided the people camping are not making the sidewalk unreasonably inconvenient or hazardous. You can always call 911 and ask for an officer to come by and see if a better outcome can be reached. She goes on and on. But the point is, she called the city and they said, can't do a thing about it. So I want to just, on this city council thing, I want to tie in something about this, and this goes back to kind of founding idea of America and how we govern, how we think about America. When the city of Austin was faced, and they may have a significant homeless problem, I don't know the specifics, but when they were faced with the people, the advocates for the homeless, coming to city council and saying, you know, you got to give them more places to sleep, they got to be able to sleep anywhere, and there were not Probably, frankly, the homeowners in Austin had no idea the city council might be thinking of passing this. So they're not hearing any other voices. And so the city council says, well, okay, as long as they don't do it near us and near our city hall, somewhere else, fine with us. So it was the height of poor work, poor engagement by the city council in Austin in really thinking through the consequences of their policies. Just thinking about the people, the loudest protesters, and not what's good for the city, and what's good for tourism, and what's good for homeowners, what's good for property values. But the deeper thought about that is this. Homelessness is not an inherent characteristic. Homelessness should not be treated by the government in just a blanket rule about anything. There are all sorts of reasons that lead to homelessness, and instead of dealing with the kinds of things that probably lead to homeless, such as drug addiction, unemployment, not sufficient skills to be able to get a job, to get hired, mental health problems, those are the things where maybe if you're a city council faced with a big homeless problem, you say, we got to focus on these ways to improve the homeless population, help reduce the homeless population. But when you just say, go ahead, sprawl out in the city, you're all over the city, you're agreeing that these people have no remedy in front of them, they must be treated as perpetually homeless, perpetually helpless, have no inherent human dignity, no way to move forward, no way that your services could help. Now, I'll be clear, I'm sure Austin offers services for people who have addiction to drugs or alcohol, and they probably say they have something going with respect to trying to help them find jobs, and they probably even have some services related to people who have mental health challenges. But the answer to surrender to the homeless mindset and say, well, you're homeless, go ahead and sleep out, is surrendering to the decline of our culture, our civility, the city of Austin, our whole culture. It's why people are lamenting San Francisco and leaving San Francisco. So, and the city of Austin, I go back to this founding idea about America. The idea of America was that every person has a right to live in this country and pursue their version of life, liberty, and pursuit of happiness. The individual freedom idea, live in freedom, is paired with individual responsibility. That's the idea of freedom in America. Personal responsibility and personal freedom. All the city of Austin's saying is, freedom, we can't fix anything, and they don't even want to turn and talk to the people in the city about and try to help the homeless population to say maybe you can find another choice. I'm going to throw in one last point, and then I got to go to my why it matters to you. But I wanted to remind you about in the state of Maine just a few years ago, the state of Maine decided that they were going to put in a work requirement for people who were collecting food stamps, for able-bodied people collecting food stamps. But if they wanted to continue to collect food stamps, they had to work, and it was some minimal amount, whatever it was, 10 or 12 hours a week. And if you couldn't find a job, you could work for the city. You could clean parks, you could something like that. People who were able-bodied and wanted to continue collecting food stamps had to work. It was Maine's welfare reform idea. So within 1 year, the able-bodied citizens who got off food stamps found a rise in their average income on an average of 114%. They had thousands and thousands of people drop off of food stamps because they weren't willing to work, meaning that they didn't need food stamps. And the idea of treating people with, we believe in you, we believe in your ability to contribute, we believe in your ability to begin to make the path toward employment. Maine proves some of that, treating people who are recipients of food stamps with the idea, we believe in you and your potential for personal responsibility and moving forward in life. And that is something the Austin City Council ought to keep in mind. And now, my friends, returning to my favorite part of the show, which is why it matters to you. Because everything we talk about in the show I do, I'm going to tell you why it matters to you. On Trump's tax battle in the court, this is political lawfare. This is the Democrats using the law to just harass their political opponent. There's no legitimate reason for the House Democrats or the New York Attorney General, who's also doing this, to go after Trump's tax returns. Americans must reject this Democrats' hyper-partisan, utterly lawless abuse of power. Stop attacking Trump for the sake of attacking Trump. Start behaving as adults and addressing duties as legislators. on the state of religious freedom. And thank you so much again to First Liberty and Lathan Watts for joining me. Crosses with historical stature are being preserved. This is a great thing. Harassment of Chick-fil-A is really at the core intolerance of religious values. Atheist intimidation of public officials is designed to silence Christians. It's relentless. It's why you always must speak up. Religious freedom is our first liberty. Christians are under assault. And I meant to say this earlier, around the world, we, America, we're supposed to be the beacon of, the example of defending freedom of religion. Support First Liberty. Great group. Insulting Congress is a crime. Okay, that was a little bit comical, but seriously, this is what a ruling class attitude looks like. July 4th is a great time to remind all Americans, America abolished the idea of a ruling class. We are governed by we, the people. American government is supposed to be of the people, by the people, and for the people. Open public debate is a beautiful thing. It includes criticism of public officials. It's fundamental to maintaining freedom. And our last story, Austin OK's sidewalk sleepers except at City Hall. Government policies that apply to everyone except politicians are inherently suspect. Big time. Meeting needs of the homeless must be balanced with the need for civil life, safety, hygiene. This is not the city council's job to make sure the homeless have everything they want. It is the job to protect the whole city, especially the taxpayers. Policy should reflect compassion and the belief in people's inherent worth and potential. Homelessness is not a normal, causeless condition. Indulging it by allowing sleep anywhere policies is hopeless surrender to the homeless lifestyle. Sleep anywhere, it validates homelessness and drags down all of society. Addressing causes like mental illness, addiction, unemployment is vital. Remember the lessons from Maine's Work for Food Stamps project. Many will respond well to demands for more responsibility. And that, my friends, is America Can We Talk for today. Please tune in every day, Monday through Thursday, 3 p.m. Central Time, where I always talk truth about America because America matters. Talk to you tomorrow, July 4th.
America, Can We Talk? Truth about America.
Can you